a bit of an issue with the sound. And for those of you who were on that webinar, thank you for bearing with us. In addition, because we are today conducting this out of Brussels, we have also invited a number of our clients and contacts to attend in person. And so for those two reasons, we thought we would try this particular webinar without the video link. So you obviously have the voices and you have the slides, and you will have to be able to do questions. But we are this time doing it without video. And so if you have any feedback on that you would wish to share with us, we would love to hear from you. So thank you for that. Today we're going to briefly cover the main developments as is customary in these webinars over the last 6 months, that is January to June 2012. And we're going to go over cartels, mergers and abusive conduct. And Silvio Capellari is now going to start with cartels. I'm handing over to him.
Can you give me the beeper, please? Thanks. Yes, hello everybody. There have been quite a number of noteworthy developments in the area of cartel enforcement in the first half of 2012. I will first discuss recent case law of the EU courts and the European Commission on certain substantive issues. Next, I will highlight some procedural developments. And at the end, I will briefly talk about the ongoing discussion regarding disclosure issues in the private enforcement area. Immediately jumping into substance, I want to start with the General Court's Dow and DuPont judgments in the chloroprene rubber cartel. In these judgments, which came out in February of this year, the court confirmed the liability of Dow and DuPont as parents of a 50-50 joint venture due to, as the court said, sufficient economic, organizational and legal links between the parents and the joint venture. As regards the general framework of analysis, the court confirmed what it had said in several other cases before, and also the Commission, namely that the Commission needs to prove two things. First, the parent's ability to exercise decisive influence over the joint venture, and secondly, also the actual exercise of such decisive influence. In the case at hand, the court then confirmed the Commission's approach. The Commission had focused on a member committee that was created within the joint venture, and it was staffed by representatives of the two parents, and this committee had far-reaching decision rights, so that made for the ability to exercise decisive influence. And as Commission and Court found, the committee also exercised these decision powers to an extent that liability of the parents should be assumed. I think more interesting than this confirmation of the well-established general framework was the way how the court dealt with certain counter-arguments raised by the parent companies. The first of those is that both parents claimed that they had no idea about the cartel activities. There the court said that this argument was simply irrelevant, and that mirrors its approach in former cases. Next, the parents claimed that the joint venture's full function character should take away their parent liability. And the court agreed on this argument insofar as it said that full functionality indeed gave the joint venture quite some economic autonomy. However, the court then went on and said that this economic autonomy does not necessarily translate into strategic autonomy, which is at the core of the question whether or not parent liability should be assumed. Third argument of the parties or of the parents was that they only exercised negative control in the member committee. They had several veto rights, but neither of them could impose decisions on the joint venture. And here the court was quite clear in stating that such negative control is sufficient for purposes of parent liability. And I think the most intriguing argument by the parties is the fourth one, And there they said that the Commission shouldn't have the best of both worlds, if you want, by assuming, for purposes of parent liability, a single economic entity between each of the parents and the joint venture, while at the same time, outside the hardcore cartel area, still viewing the joint venture and parents as two separate economic entities when it comes to the application of Article 101 of the EU Treaty. And there I think the reasoning of the court was quite thin, because the judges simply held that the parents did not have a legitimate expectation that the previous approach of the Commission under Article 101 will be maintained in the future. The conclusions from these important judgments, I think, first, they clearly confirm the tough approach of the General Court and also the Commission on parent liability, also for 50-50 joint ventures. And there were also some quite important, though perhaps not very surprising clarifications on the aspects of full functionality and negative control. Third point is that the General Court stresses at various times the need for a very detailed fact-specific analysis, and this is, I think, some glimpse of hope, if you want, for the companies. And in fact, in March 2012, regarding the industrial banks cartel, the court said that the Commission was wrong in assuming liability of joint venture parents for a joint venture in which they had 60% for a certain period of time for which the Commission had not adduced sufficient factual evidence. So while the general framework now has become clearer, it still all boils down to a very fact-specific assessment. Before we leave the courts on substantive issues, I found these statistics on the present slide covering the period between March 2011 and March 2012. It focuses on the general court proceedings in cartel cases, and there were 75 rulings during that period. And the first interesting point I want to make is that in 35 of these rulings, so almost half, the Commission decision was partially or fully annulled. And that led to a reduction of total fines from 3.6 billion euro to 3 billion euro, so more than 16%. And also interesting, I think, is an overview of the successful claims made in these cases by the parties concerned. As you can see, by far the most successful claims related to the wrong or insufficient factual analysis by the Commission. There were 23 successful claims in that regard, 14 alone relating to duration, meaning that the Commission, according to the court, had assumed a wrong start date or a wrong end date of the infringement. Also quite successful were claims regarding the application of the fining guidelines, whereas claims on parent liability and general legal issues like the statute of limitations played a lesser role. Turning now to the decisional practice of the Commission, there were 4 cartel decisions during the relevant period. The first one, and the, I think, most important one, concerned the window mountings cartel. In that case, the Commission imposed fines of almost 90 million euros on 9 companies. However, the fines could have been or would have been even much higher if the Commission had followed the calculation method set out in its fining guidelines. And this is due to the fact that most of the cartel participants were single product firms. That would have led, because the cartel had gone on for several years, that would have meant that the fines would have been far above the 10% turnover cap provided for in the relevant legislation. And the court said, so it would have had to be capped at 10%. And there the Commission said, including Commissioner Almunia, that that would have been disproportionate, and therefore the Commission decided to apply exceptionally point 37 of the finding guidelines. You see the wording on the slide. And due to this exceptional application, the fines in the end were considerably lower. We cannot say by how much lower, because we still wait for the publication of the full non-confidential version of the decision. This is clearly another, and I think quite important example of the Commission's increased flexibility on fines. Another example in that regard is, of course, the increased willingness of the Commission to accept inability to pay claims. The decision led to quite some discussion and noise in the market here in Brussels, and in reaction to that, several Commission officials stressed the fact-specific nature of the decision. However, I think it is to be expected that in the future many companies will try to make an analogy to the facts underlying that decision. The other three Commission decisions I only want to mention briefly. First one is in the freight forwarders case. As you can see, fines of almost 170 million euros. This is a follow-up case to the air cargo case decided in 2009. Once the full version of the decision is out, we will have a clearer picture, but from the available materials, it seems that the Commission apparently took a different approach to the question of a single and continuous infringement. In both cases, there was coordination at issue on different price components like surcharges and discounts. In the air cargo case, the Commission assumed only one single cartel comprising all these aspects, whereas in the freight forwarders cartel, it apparently assumed 4 different cartels. Secondly, decision regarding water management services. Here the fine is quite low, the total fine, and there were just 3 companies involved. I mention this case mostly because it's the Commission's 6th settlement case. And finally, in the never-ending gas-insulated switchgear saga, the Commission had to readopt the decision as far as Mitsubishi and Toshiba were concerned. And as you can see, this led to a significant fine reduction for both companies. Turning now to procedure. The first development worth mentioning here is a reform of the EC's procedural framework for antitrust investigations. In late 2011, the Commission published a package or issued a package with 3 main components. The first of those is a notice on best practices, and I highlight here just 3 aspects. The Commission commits to conduct state of play meetings at key points of the proceedings. The Commission also said that it will grant access to key documents already during the investigative phase and not only after a statement of objections has come out. Of course, it remains to be seen how the term key documents will be interpreted. And third, the Commission will already in the statement of objections set out information regarding the parameters it intends to use for the fine calculation, such as the relevant value of sales, duration and gravity of the infringement, and so on. The second component of the package is an extended mandate of the hearing officer, and here the focus is on greater supervision rights for the hearing officer regarding the exercise of rights of defense at all stages of the proceedings, in particular as far as disputes about privilege issues and questions of self-incrimination are concerned. And also the role of the hearing officer in the preparation and then the conduct of hearings is supposed to become even stronger. The third and last component of the package are best practice guidelines for the submission of economic evidence. Shortly after that package, the Commission also published its so-called Manual of Procedure, or in Brussels slang, its MAN-Proc. These are internal guidelines regarding the handling of antitrust investigations, and the publication was triggered by the request of a Brussels lawyer under the regulation 1049 of 2001, also known as Transparency Regulation. And this manual is quite voluminous and has no less than 28 chapters, which deal, among others, with the handling of complaints, the treatment of immunity and leniency applications, and also the quite complex decision processes within the EC, so the European Commission. 2 chapters are left out for the time being. The Commission said they are still under construction, concerning sector inquiries and fines and remedies. And in particular, the latter one on fines and remedies is of course of particular interest. So we all hope that this chapter will soon be published as well. What will never be published is a chapter on dawn rates, because there the Commission said that an exception in the transparency regulation regarding the protection of the Commission's investigations applies. Moving away from, if you want, the legislative framework, a few words on, I think, a clearly increasing trend regarding litigation on dawn rate related issues. And here a highlight was an opinion by Advocate General Bott regarding the Eon case. This concerned the breaking of a seal during dawn rate, and the Commission had imposed a fine of 38 million euros on Eon, and this decision was upheld by the General Court. The Advocate General was not happy with that and recommended a partial annulment of the decision, because in his view the court had not sufficiently analyzed the method used by the Commission to calculate the fine for Eon. And in that regard, he pointed out that a detailed proportionality analysis needs to be carried out, which needs to take into account 2 different factors, namely first, the seriousness of the infringement as such, here the breaking of the seal, but secondly also the fine that Eon would have incurred if found guilty of a cartel infringement. The Advocate General also said that the fine needs to have a sufficient deterrent effect. Taking all that together, the general view of that opinion is that if it is followed by the Court of Justice, Eon has to expect an, I would say, even higher fine than the 38 million euros. The original Commission decision against Eon, it had come out in 2009. In 2011, the Commission imposed yet another fine for the breaking of a seal of, in this case, only 8 million euros on 2 French companies. And just as an example of further dawn rate related litigation, in March 2012, the Commission also imposed 2.5 million euros on 2 Czech companies because they had obstructed a dawn rate inspection. At the same time, it should be noted that there is also increasing litigation from companies subjected to a dawn rate. For instance, there are 2 appeals pending by Nexans and Prysmian in the power cables cartel. They focus on the fact that the Commission's team had taken copies of entire hard drives from the company's premises for review at the Commission's premises. And we are, well, it will be very interesting to see how the court, the General Court, will deal with these complaints. Last part of my bit of the presentation concerns private enforcement, and here disclosure issues. I guess many of you will be familiar with the Court of Justice's Fleiderer judgment of mid of last year, where the court held that the EU competition rules do not preclude claimants from getting access to leniency documents contained in the case files of national competition authorities, and that instead the national courts need to carry out a balancing between their national law and the EU law interests. This ruling was applied by 2 courts, first in Germany, then also in the UK. And in Germany, a lower court held that after carrying out the balancing test, the claimants should not get any access to leniency applications and supporting evidence, documentary evidence, in the case file of the Federal Cartel Office, because the protection of an effective leniency program prevails over the interest of the damage claimant. A somewhat more nuanced approach was taken a little later in April by the UK High Court in the National Grid case. There the court said, well, at issue there was not access to corporate statements, but to documents which reflected information provided in these corporate statements. And the court first held that the Fleiderer test should also be applied to documents in the Commission's file, and then carried out the balancing test with particular focus on the principles of legitimate expectations and proportionality. And at the end of that balancing process, the court reviewed all the various documents at issue in this case and came up with a ruling that additional 32 paragraphs of the confidential version of the Commission's decision should be revealed. At the same time, there should be only very limited access to responses to requests for information and no access at all to responses to the statement of objection, because the judges didn't see relevance of that information for the claimant's case. A little after the decision by the UK High Court, the heads of the various competition authorities in the EU member states published a joint resolution. You see the key sentences from the joint resolution on this slide, and it becomes clear from that resolution that the competition authorities want to protect the leniency documents in their files to the greatest extent possible. Nevertheless, there is at this point a significant legal uncertainty, and claimants clearly look now for forum shopping and other opportunities to exploit that legal uncertainty. The EU, the Commission, has seen that problem and wants to counter it with legislation, which may already, at least in draft form, already come out in 2012 towards the end of the year, and will probably be in the form of a directive rather than a regulation or best practice guidelines. The topics covered by that directive would be, first, the question I just discussed, the access to the case file protection of leniency programs, but also issues of standing of indirect purchasers, its mirror image, the admissibility of the passing on defense, and ways to make decisions by national competition authorities legally binding in all EU member states. And this is my last slide, I will be very short on that. Some claimants have tried other avenues outside the cartel-specific rules to get access to documents in cartel cases and cartel files. And here I just want to point out a striking difference which seems to exist between the General Court's approach and the approach of the Court of Justice. Because within not much more than 1 month, the two courts issued very different judgments. According to the general, I have to say that in both cases the question was to what extent claimants could get access to leniency documents under the transparency regulation I had mentioned earlier. And the General Court said that the right access to documents under this regulation needs to be interpreted broadly, and any exception to it, therefore, needs to be interpreted and applied very strictly, which means that the Commission, according to the General Court, needs to look at each individual document and come up with an explanation if it does not want to make it accessible. Very different, the Court of Justice in Edition Odile Jacob, which related to merger proceedings. The Court of Justice argued with certain categories of documents and said that to these categories of documents, a general presumption applies that they do not need to be made accessible to claimants. And I think the two categories involved here are very important. The first one is the Commission's correspondence with the merging parties and third parties. And the second one, the second category, are EC internal documents. So for these two categories, according to the Court of Justice, the Commission does not need to come up with any kind of specific justification. The Commission instead can just deny or refuse access. Question, of course, is to what extent this judgment is relevant outside the merger area. At a recent conference, Commission officials said that the Commission very much takes the view that the Court of Justice also wanted to make some general statements regarding the antitrust field in this judgment. With this, I turn over to Marlene for developments in the merger area. Yeah.
Thank you, Silvio. Moving on to mergers, by way of background, just wanted to show you these figures showing the number of cases, or at least some of the parameters that the European Commission publishes on its website when it comes to statistics in merger control. And one thing that obviously is very striking from this is that there continues to be, I think in phase one decisions, about 2/3 are simplified procedure cases, where less information is required and indeed a lighter investigation is conducted by the European Commission. And interestingly, it's in that area also that the Commission is proposing to further assist companies by streamlining that process even more, so that in cases where there are obviously no issues of substance, that the burden on companies is made somewhat lighter. The other thing which is worth noting, I think, is the fact that there have been in total 6 commitment decisions over those 6 months, which obviously is again a very small number, looking at the total number of filings that have been made. And then we see a slight increase in appeals. There have been 4 appeals brought in the last 6 months. One was against the one and only prohibition decision that we've had in that period, and that was the Deutsche Börse case. But then also 3 appeals against clearance decisions. One where a third party challenged the fact that the Commission had cleared a transaction without commitments. Another one where one of the merging parties objected to the commitments that were imposed. And another one where a third party objected to the commitments that were imposed. So a variation of cases, and I think worth following once they get to the court. The trends in merger control, or at least the recent trends in merger control, I've already mentioned the streamlining of the simplified procedure. Another trend, but not something on which we will see a change tomorrow, is the fact that the European Commission is looking much closer into whether or not it should include in merger control the acquisition of minority shareholdings. Today, such acquisitions only require notification, and that is assuming the transaction exceeds the thresholds, the revenue thresholds, if the acquisition leads to joint control with other parties. Now, in the future, the Commission is wondering whether it should also include non-controlling minority acquisitions. And what actually triggered that soul-searching exercise is the fact that when Ryanair, the first time round, tried to acquire Aer Lingus, this was a bid, and it acquired about 25% or so in the process. The Commission ultimately prohibited that transaction, and Aer Lingus then challenged the fact that Ryanair still had the 25%. That was appealed, and Aer Lingus lost the appeal. And that is actually one point that the European Commission is also considering if it is going to have to deal with issues like that, is the solution that minority acquisitions without control will need to be notified or possibly looked at post-fact, or is an alternative that indeed when it comes to suspending transactions, not implementing transactions that are notifiable, that a change needs to be made in those rules. So that's in the works, and the Commission is in the process of collecting data, and I think it will be a little while before we see concrete proposals. Another helpful trend is sorry, I shouldn't call the first one helpful, but when you're talking about simplifying the procedure, that is obviously helpful. So in that category of trends, there is also a clear effort by the European Commission to simplify, or at least to make the pre-notification contacts more flexible, more informal and shorter. I think my personal view is that that has to do also with the issue of priority of cases that I will come back to in one of the next slides. But we see it in the cases that we currently have before the European Commission, that, for example, where before it was rather more elaborate, you would start with a memorandum and then a draft form CON, etc., etc. They're now much more keen to immediately look at draft notifications, to give feedback on a rolling basis, to have informal discussions if it's easier over the phone rather than face-to-face meetings, even having state of play meetings over the telephone rather than in person if that facilitates, etc. So there is clearly an effort to be more efficient and more flexible there. Then I mentioned this issue about priority, and that is something that, I mean, it played out last year, but we have now seen the publication of the decisions in one of those two cases, within that decision an explanation by the European Commission why it proceeded the way it proceeded. And the issue was the following. These were two transactions that were basically happening in parallel in relation to hard disk drives. The first one was Seagate Samsung, and the second one was Western Digital VVT, a Hitachi business. And they were so much in parallel that both of them contacted the EC for pre-notification contacts very much around about the same time. One, Seagate on the 14th of March and Western Digital on the 10th of March. And then obviously went through the normal pre-notification contacts with the Commission, and it so happened that the one that contacted the Commission first notified one day after the one that contacted the Commission second. And the Commission has a rule that it looks at, on the merits, at the market conditions at the time of notification of the transaction that is before it, as opposed to looking at, in this case, the fact that the next day it received a notification in exactly the same industry, which would reduce the number of players not only from 4 to 3, but from 3 to 2. There was a lot of reaction to that approach. It's an approach that other jurisdictions do not follow, like, for example, the United States. And it is also something that at the time Western Digital challenged before the European courts. The end of the story was that both transactions were sent into second phase investigation. The first was cleared without commitments, the second was cleared with a commitment. And then looking at indeed how the European Commission justified its priority rule, indeed based on the fact that you have to look at the time of notification, it says that these are the competitive conditions that we need to look at, and that's the objective criterion, transparent criterion, and criterion of legal certainty that we think we need to work with. And we don't think it is neither necessary nor appropriate to take into account future changes resulting from subsequently notified transactions. Now, obviously, if you're talking about future changes, that is just coming one day after the earlier notification, that is, of course, extremely sharp. And the question is, of course, also, how does it work with these pre-notification contacts, and to what extent is it the initiative of the companies as opposed to the initiative of the Commission, and the need not to jeopardize the relationship with the case team if one rushes in with a formal notification. So my earlier comments about more flexibility on the pre-notification phase may possibly have something to do with that. Then another aspect which we don't see very often, in fact I don't think I've ever seen in merger investigations, is dawn raids. Again, this is a case that I think we have reported on before. It's a case that was decided at the end of last year, but information has now become available through the publication of that decision this year. This is Caterpillar MWM. It was also a phase 2 investigation. It was ultimately closed without commitments, but shortly after the opening of the phase 2, the European Commission conducted inspections at the merging parties, apparently, so it explains in the decision, because it had concerns over lack of bidding data, and the bidding data were particularly critical in this case, because a key argument on the substance was closeness of competition between the different players, and obviously in the first instance between the two merging entities. There was apparently also concern that misleading information had been provided, and also some suggestion that there might have been early implementation of the transaction. Again, you will know that when you're talking about particularly a phase 2 investigation, there's enormous amounts of information that need to be provided to the Commission, and sometimes it is complete, sometimes it's not complete, sometimes it is available, sometimes it's not available. So again, it's difficult to judge whether this was clearly something that went wrong, or whether there was a frustration on the side of the Commission that it didn't get what it hoped to receive, or a mixture of both. In parallel, and that is also interesting, the European Commission sent at the same time in that investigation Article 11.3 letters for information to the industry association concerned and to certain members. Again, this is spelled out in the decision. An Article 11.3 letter is a fairly strong move by the European Commission, because it's a procedure whereby they can actually impose fines if you don't reply within the time set. So again, that was quite an exceptional move by the Commission there. And then in addition, there was a parallel investigation started, an Article 101 investigation into the issue over the bidding data and the information being collected. But according to press reports, which the European Commission has not confirmed, that case has since been closed. Another aspect which I just briefly wanted to mention without really going into the detail of the substance, but it's an interesting case also that's currently pending before the European Commission in Hutchinson 3G Austria and Orange Austria, where the two are hoping to merge. And again, it's a transaction 4-3. And prior to the transaction, I'm assuming as a result of issues that they could foresee happening with this transaction, Orange, so the target, would sell or did agree to sell its Yes customers to another telecoms operator in Austria, but conditional on the first deal closing. This second deal was smaller, so that was filed in Austria. The first one was filed before the EC, and both have now gone into a second phase. In addition, Austria asked for a referral back, but to my knowledge that has not been granted. So it will be very interesting to see how the timetable plays out in that case and what the ultimate outcome will be. Then I also wanted to say a few things about the Google Motorola mobility case. The reason being that it's one of few cases at any given time that sort of spells out in quite a bit of detail how the European Commission looks at vertical foreclosure issues, whether it's input foreclosure or customer foreclosure. And the vertical relationships in that case were, on the one hand, Google's Android mobile operating system, and where the Commission said, well, despite the fact that it's an open system, we think we should attribute its entire share to Google, and I think that was in the range of 40 to 50%. So that's the Android system on the one hand, and the Motorola Mobility smart mobile devices on the other hand. That was one vertical relationship. And then the other aspect the Commission looked at was the standard essential patents that Motorola Mobility had, and they obviously constituted a key input into the smart mobile devices industry. So on the first relationship, the operating system versus input foreclosure, the Commission did obviously the three standard tests of, is there an ability to foreclose, an incentive to foreclose, and even if there was, would there be an effect? On the ability to foreclose, the Commission said, well, yes, Google may or may not have an ability to favor one or other OEM to partner with its Android system, and it may indeed favor Motorola Mobility, but that will not change as a result of the merger. On the incentives to foreclose, the Commission thought that it was doubtful that Google could capture more profits from favoring the Motorola Mobility devices rather than having a large base for its search and advertising services, in other words, in favor of an open system. And finally it said, well, even if there was foreclosure, that would have a limited impact since most competing OEMs have alternative operating systems to turn to. So on the first point, the Commission concluded that there wasn't really an issue. The second concern in relation to the standard essential patents and the interplay with the mobile devices, there the Commission had concerns about, or at least looked to what extent there could be concerns about the merged entity raising royalty levels or forcing potential licensees into cross-licenses on terms that they would not otherwise have to agree to. Or indeed excluding competitors from the market. Again, on the ability side, the Commission said that despite the fact that there were, of course, friend obligations, also in law, that Google had some ability to seek or threaten injunctions, but that only applies to non-licensees where, in fact, Motorola Mobility had already sought injunctions. So again, the concern there was not a merger-specific concern. In addition, on the incentive side, the Commission noted that Motorola Mobility currently had a maximum per unit royalty that was non-merger specific, and that Google had limited incentives to raise that level, including its obligations under friend. In addition, there were Google internal documents that the Commission received, and that showed that the aim of the transaction was exactly to protect the Android ecosystem rather than impede competition. And in addition, Google made a public statement that it was and remained committed to friends. And in fact, that letter is available on the website if you wanted to see that. And in fact, it's interesting to see that also in the Commission in relation to the matter, in the decision in relation to the letter, the Commission says, well, we're not quite sure that what is described there is entirely consistent with how we, the European Commission, interpret friend, but nevertheless we still have our ability to apply the rules as we think they should be applied. And we also note that Google's interpretation of friend is largely in line with the current case law of the German civil courts. So that was, I thought, also an interesting comment. And then finally, it found that none of Google's internal documents provide evidence that Google would seek injunctions against its competitors with the aim of ultimately excluding them from the market. And so on the effect side also, the Commission didn't find an effect that would be merger specific. The interesting aspect also on this one that I wanted to flag is the increasing importance and practice indeed by the European Commission to ask for internal documents, and they can be indeed, as in this case, a very helpful way of convincing the European Commission or helping to convince the European Commission of the merits of your case. And indeed both, as here is shown, both on showing what the rationale of the transaction is and showing that you don't have any intention of foreclosing or otherwise bundling or whatever the Commission might be concerned about. Then the famous or infamous prohibition decision. I think you all are aware of the fact that the Commission prohibited the Deutsche Börse Euronext transaction. That centered very much on the issue of market definition, and obviously at the risk of oversimplifying a very complex case in just a few lines, but the European Commission defined the relevant market as European financial derivatives traded on exchanges, i.e. exchange-traded derivatives, as opposed to over-the-counter trade derivatives. Traded, so that should be derivatives. And so that created apparently a near monopoly with, according to the findings of the European Commission, high barriers to entry, less innovation and no offsetting efficiencies, and I'll come back to that briefly on the next slide. It's interesting indeed that it was very much the market definition issue that determined that case. So much even that if you look, and it's interesting to look at if you want to take the time, at the European Commission decision where this decision, meeting of the European Commission where this decision was discussed in the plenary, the issue of market definition was one of the very specific items that they discussed, and whether there had been a mistake there. So again, worth looking at, and we can certainly send you a copy if you're interested. Then prohibition and efficiencies. As you know, we have, like other regimes, the possibility to justify what might otherwise be unacceptable with reduction in competition with countervailing efficiencies. And here again, Almunia made a point in a presentation at the end of June to again refer to Deutsche Börse and saying, well, yes, we did look at efficiencies, but we couldn't find anything that would have been transmitted to the investors. And so without that, we cannot accept efficiencies, but we will continue to look at efficiencies. And then finally, just a few words on commitments. As I mentioned, there haven't been too many decisions in the last 6 months with commitments, and I've only picked out two. And again, the second, in fact, is from the end of last year, but as we mentioned earlier, the decision was published this year. One thing that I wanted to flag on the first case, the Sony BMI decision, which was about online licensing of copyright, was that the Commission had a concern about the fact that the merged entity would control a large chunk of the Anglo-American chart hits. So much even that I think up to half of the chart hits in the UK and Ireland would be in whole or in part controlled by the merged entity. And so a divestiture was required. The parties offered 4 catalogues and recent and future works of 12 Anglo-American artists. But interesting enough, it asked for the divestiture of the global rights, not just the EC or let alone the UK and the Irish rights. And then on Western Digital, the one point I wanted to flag there, again, I mean, the divestiture as such is not exceptional. But it's interesting to note that there was a concern not just about on the side of the Commission, not just to preserve competition, but also to preserve innovation. And therefore they added an explicit obligation that the buyer of the asset should have innovation capabilities. And that is the chapter on mergers. I'm now turning over to Axel for abuse of dominance.
Thank you, Marlene. I will start by explaining what has happened at the Commission and then discuss court judgments concerning Article 102. The Commission has not adopted any formal decision regarding Article 102 in the last 6 months, neither under Article 7 of Regulation 1, which are the traditional prohibition decisions typically coupled with a fine, nor under Article 9 of Regulation 1, which are the commitment decisions. And most of you will know that the enforcement tool that the Commission most often uses these days in Article 102 cases are these commitment decisions. There have nevertheless been some interesting developments at the Commission. The Commission has opened formal cases against Samsung and separately against Motorola. And these cases related to an alleged failure of these companies to honor their commitments that they had made to the European Telecommunications Standards Institute, ETSI, by seeking and enforcing injunctions in various member states' courts against competing mobile device makers based on alleged infringements of certain of their patents, which they had declared essential to implement European mobile telephony standards. In other words, these cases, in essence, relate to the question whether Article 102 prevents the holders of standard essential patents to seek injunctions preventing non-licensed users of the patented technology to indeed make use of that technology. In the Thomson Reuters case, which has been pending for quite some time, the Commission rejected the initial set of commitments that Thomson Reuters had offered, and in May 2012, the Thomson Reuters offered an improved set of commitments, which is now being reviewed by the European Commission. Another case that was formally opened by the Commission is a case against MathWorks, and that case concerns an alleged refusal to provide competitors with end-user software licenses and interoperability information. And the Commission, in its press release regarding the opening of the case, stated itself that this case is similar to the Microsoft case in many respects. Then turning to the court activity, we have 4 court judgments that have come out in the last 6 months, and that is a relatively high number. And I will cover them to some extent now, but they are obviously interesting reading under many aspects, and I will just cover some of them now. So the first case is a preliminary ruling case where the judgment was issued by the Grand Chamber of the Court of Justice involving the Post Denmark. Post Denmark is the incumbent Danish postal operator, which had a monopoly for addressed letters and parcels under a certain weight and a universal service obligation in that regard. But the relevant market here was the market for distribution of unaddressed mail in Denmark, and unaddressed mail notably includes advertising brochures that supermarket chains have delivered to households. On that market, Post Denmark was found to be dominant, even though the market was liberalized. And you can read afterwards the rest of the facts here. We will send around this slide package to all participants, I will immediately go to the legal issues now. This case involved predatory pricing. And as many of you know, predatory pricing is being assessed in Europe, at least under the court's case law, under the so-called AXO test, which was established by the Court of Justice in a case against AXO about 20 years ago. And in that case, the court established two categories that were relevant for establishing whether prices applied by a dominant company would be predatory and thus abusive. The first category is where the prices are below the average variable costs of the dominant company. And in that case, there's a presumption that these prices are abusive because with every additional quantity of product sold, the company increases its losses. The second category is when the prices are above the average variable costs, but below average total costs. And such prices are only abusive if there is a plan on the part of the dominant company to eliminate a competitor. Now, in this case, the situation was that Post Denmark had offered particularly low prices to win customers of a competitor on the market for unaddressed mail services, and in particular to 3 supermarket chains that previously were customers of the competitor. And for one of these customers, the Co-op supermarket chain in Denmark, Post Denmark's resulting price level was lower than Post Denmark's average total costs for the business of delivery of unaddressed mail. But it was still higher than Post Denmark's average incremental costs, which is approximately the same and was accepted in this case by the Court of Justice as average variable costs. So we were in the second category of the AXO test, but importantly, the Danish authority, which had initially reviewed the case, found that explicitly stated that it was not able to find that Post Denmark had a plan of eliminating this specific competitor. And so it was not possible to establish a predatory pricing abuse under the AXO test. And so the Danish court referred the question to the ECJ whether in this situation a predatory pricing abuse could be found. And here's the answer that the Court of Justice gave. It said that a policy by which a dominant undertaking charges low prices to certain major customers of a competitor may not be considered to amount to an exclusionary abuse merely because the price that undertaking charges one of those customers is lower than the average total costs attributed to the activity concerned, but higher than the average incremental costs pertaining to that activity. However, the court continues, in order to assess the existence of anti-competitive effects in circumstances such as those of that case, it is necessary to consider whether that pricing policy without objective justification produces an actual or likely exclusionary effect to the detriment of competition and thereby of consumers' interests. So the bottom line is a selective price cut for one customer of the competitor, which leads to prices in the second AXO category, does not constitute an automatic predatory pricing abuse, but an abuse can nevertheless exist, and that depends on the effect that the price cut has on the market. What is interesting is that this answer of the court does not refer to a plan to foreclose, which is nevertheless a relevant aspect under the AXO judgment for situations of the second category. Now, it's not quite clear to me whether this is because the Court of Justice now believes that a plan to foreclose no longer is really relevant, but that it's only the effects that matter, or whether the court didn't address this point because the referring court explicitly stated that in this case, a plan was found not to exist. Now, a second aspect of the case is discrimination, because if we talk about selective price cuts, the issue comes up whether those could constitute a discrimination abuse. Interestingly, in this case, the referring court explicitly asked for a preliminary ruling on the existence of an exclusionary abuse. And so the issue of discrimination did not come up. The Court of Justice simply stated that the presence of price discrimination cannot of itself suggest that there exists an exclusionary abuse. And the reply that the court gave also was limited to exclusionary abuse. So in my view, this leaves for companies the question, if we have selective price cuts which do not lead to exclusion, is it nevertheless possible that these price cuts would be held abusive because they discriminate between different types of customers? The second court judgment I want to speak about is the Microsoft judgment of the General Court on the application for annulment that Microsoft had lodged regarding the euro 899 million periodic penalty payment that the Commission had imposed against Microsoft in 2008. And you will remember that the reason for that penalty was Microsoft's non-compliance with the 2004 Commission decision for a period of 16 months in 2006 and 2007. The 2004 decision in turn, as you will also remember, is the big Microsoft decision, which required Microsoft to make interoperability information available on reasonable and non-discriminatory terms. And this interoperability information concerned the interoperability of Microsoft Windows PCs and workgroup server operating systems of competitors. The 2008 decision of the Commission, which was the subject of the application for annulment, held that the interoperability information or the terms that Microsoft had offered to make this interoperability information available was not reasonable until Microsoft had revised that offer in October 2007. The General Court upheld the Commission's decision and merely reduced the fine a little bit because of an aspect relating to the gravity of Microsoft's conduct. There were two preliminary aspects of this case. Microsoft said, well, my obligation was to offer this information on reasonable terms, but it was not clear what this really means. And so this cannot be the basis for an imposition of a periodic penalty payment. The General Court disagreed and found that the obligation was sufficiently clear for Microsoft, and so that this was not a reason to annul the decision. A second preliminary issue was that Microsoft had argued that the initial offer that it had made was not really, maybe not necessarily immediately reasonable, but it was only meant to be a starting point to negotiate with the potential licensees, and that this would ultimately lead to a reasonable royalty level or remuneration level. And another aspect in that regard that Microsoft raised was that in any event there was the possibility to go to the monitoring trustee. There was also a specific dispute resolution procedure that was available. And so ultimately the claim was a reasonable remuneration rates for the information would always result. Again, the General Court rejected this. And so the issue was in the end, was the remuneration level that Microsoft offered reasonable or not? And the Commission decision, and following it, the court said that this depends on a distinction between strategic value and intrinsic value of the information that had to be made available. And the theory is that that Microsoft could not charge or impose a remuneration level that would reflect the strategic value of the information, but only a remuneration level that reflects the intrinsic value of the information. What is strategic value? Strategic value would be remuneration rates that reflect the value that result from the mere ability to interoperate. By contrast, the intrinsic value of the interoperability information is established as follows, and that goes back to an agreement that Microsoft and the Commission had reached early on to determine what the reasonable remuneration level would be. And that is referred to as the Workgroup Server Protocol Pricing Principles. These principles contain three elements. The first is the information, so the protocols that are included in the interoperability information had to be Microsoft's own creation. It must not have been taken from the public domain. The second element of the test is that the protocols must reflect innovation. In other words, they must be novel and not obvious to persons skilled in the art. And in this respect, the court agreed that these terms could be interpreted as they are interpreted under the European Patent Convention. And indeed, on this point, in the decision, the Commission had found that only a very small portion of the protocols in question, which were included in the interoperability information, reflected really innovative information. And the third point, the third element of this test is that even if under the two previous tests there is no problem, it's nevertheless necessary to make a market valuation of comparable technologies because if other companies offer comparable technology for free, then that is an indication that any charging of remuneration would reflect the strategic value rather than the intrinsic value. And so, as I said, the General Court endorsed this approach. So a few points there. The burden under this judgment is on the dominant company to establish reasonable royalty rates at the outset, in the first offer. So procedural safeguards like dispute resolution mechanisms do not help to avoid a finding of non-compliance. Certainly one can raise the question whether this three-step approach that the court endorsed to assess the intrinsic value of information, whether that will be practically possible to apply in all cases. And in this respect, very important it is to recognize that the 2008 decision, which imposed the periodic penalty payment, only related to Microsoft's non-compliance with the initial decision with regard to that information which was not patented. Microsoft had made the interoperability information available under different sets of agreements, and one was the so-called no patent agreement. And under this agreement, the licensee would not acquire any patent license. And so it is clear that this judgment only applies to information which does not include patented information. And that also means, as you know, the question of reasonable royalty rates is a big issue currently in the context of friend licensing in the area of standard setting. And so it's questionable whether this judgment has any can offer any reasonable guidance for that issue at all. Now, very briefly, I will just mention, and you can read it in the slides, the third judgment that came out was from the Court of Justice in the Tomra case. The Court of Justice upheld the General Court's earlier judgment, which had upheld the Commission's decision, so that is final now. Interestingly, this case is interesting because it addresses the question whether before finding that certain exclusionary conduct of a dominant company, like for example loyalty rebates or exclusive agreements with customers, whether such conduct can be found to constitute an abuse, even if it's not established what portion of total demand is covered by these abusive practices. It's the so-called market coverage of the behavior. The Commission had not established that in its decision, but the courts, both the General Court and the Court of Justice, agreed that that was not necessary, as long as it was clear at least that a substantial part of the market was affected by the exclusionary practices in question, and that was the case here. It was approximately 40%. And just the second interesting point about this judgment is that it seems there that the court is reverting back to the older case law on loyalty rebates by holding that it is not necessary to make a price-cost comparison of the dominant company to establish that retroactive rebates constitute an abuse of dominance. The fourth judgment, which I will just mention, and again you can read the points here, is the Telefonica judgment from the General Court. The Commission had imposed a fine on Telefonica in 2007 for a margin squeeze
in the first half of 2012. I will first discuss recent case law of the EU courts and the European Commission on certain substantive issues. Next, I will highlight some procedural developments, and at the end I will briefly talk about the ongoing discussion regarding disclosure issues in the private enforcement area. Immediately jumping into substance, I want to start with the General Court's Dow and DuPont judgments in the chloroprene rubber cartel. In these judgments, which came out in February of this year, the court confirmed the liability of Dow and DuPont as parents of a 50-50 joint venture due to, as the court said, sufficient economic, organizational and legal links between the parents and the joint venture. As regards the general framework of analysis, the court confirmed what it had said in several other cases before, and also the Commission, namely that the Commission needs to prove two things. First, the parent's ability to exercise decisive influence over the joint venture, and secondly, also the actual exercise of such decisive influence. In the case at hand, the court then confirmed the Commission's approach. The Commission had focused on a member committee that was created within the joint venture, and it was staffed by representatives of the two parents, and this committee had far-reaching decision rights, so that made for the ability to exercise decisive influence. And as Commission and Court found, the committee also exercised these decision powers to an extent that liability of the parents should be assumed. I think more interesting than this confirmation of the well-established general framework was the way how the court dealt with certain counter-arguments raised by the parent companies. The first of those is that both parents claimed that they had no idea about the cartel activities. There the court said that this argument was simply irrelevant. That mirrors its approach in former cases. Next, the parents claimed that the joint venture's full function character should take away their parent liability. And the court agreed on this argument insofar as it said that full functionality indeed gave the joint venture quite some economic autonomy. However, the court then went on and said that this economic autonomy does not necessarily translate into strategic autonomy, which is at the core of the question whether or not parent liability should be assumed. Third argument of the parties or of the parents was that they only exercised negative control in the member committee. They had several veto rights, but neither of them could impose decisions on the joint venture. And here the court was quite clear in stating that such negative control is sufficient for purposes of parent liability. I think the most intriguing argument by the parties is the fourth one, and there they said that the Commission shouldn't have the best of both worlds, if you want, by assuming for purposes of parent liability a single economic entity between each of the parents and the joint venture, while at the same time, outside the hardcore cartel area, still viewing the joint venture and parents as two separate economic entities when it comes to the application of Article 101 of the EU Treaty. And there I think the reasoning of the court was quite thin, because the judges simply held that the parents did not have a legitimate expectation.
Last one, a bit of an issue with the sound. And for those of you who were on that webinar, thank you for bearing with us. In addition, because we are today conducting this out of Brussels, we have also invited a number of our clients and contacts to attend in person. And so for those two reasons, we thought we would try this particular webinar without the video link. So you obviously have the voices and you have the slides, and you will have to be able to do questions. But we are this time doing it without video. And so if you have any feedback on that you would wish to share with us, we would love to hear from you. So thank you for that. Today we're going to briefly cover the main developments as is customary in these webinars over the last 6 months, that is January to June 2012. And we're going to go over cartels, mergers and abusive conduct. And Silvio Capellari is now going to start with cartels. I'm handing over to him.
Can you give me the beeper, please? Thanks. Yes, hello everybody. There have been quite a number of noteworthy developments in the area of cartel enforcement that the previous approach of the Commission under Article 101 will be maintained in the future. The conclusions from these important judgments, I think, first, they clearly confirm the tough approach of the General Court and also the Commission on parent liability, also for 50-50 joint ventures. And there were also some quite important, though perhaps not very surprising clarifications on the aspects of full functionality and negative control. Third point is that the General Court stresses at various times the need for a very detailed fact-specific analysis, and this is, I think, some glimpse of hope, if you want, for the companies. And in fact, in March 2012, regarding the industrial banks cartel, the court said that the Commission was wrong in assuming liability of joint venture parents for a joint venture in which they had 60% for a certain period of time for which the Commission had not adduced a sufficient factual evidence. So while the general framework now has become clearer, it still all boils down to a very fact-specific assessment. Before we